Talk shoes.
Recorded live.
Recorded live. Well, we're recorded live.
Live.
All right. Well, we're live, and that's great. Thanks, Matthew. Welcome, everybody. And one of the things I want to share with you right off the bat here this evening is we already gave our little disclaimer there. So, again, we'll just say again that we're not going to be giving any legal advice. We're not giving any tax advice. We're not attorneys. We're not accountants. We're just people that want to gather and we want to exchange information. We want to share information openly and honestly. And if you hear something on this call tonight, we're not telling you to go out and do anything. We're not suggesting it. We're not doing anything. You're going to hear some opinions. You might hear about some people and what they've done and some administrative remedies. But again, we're not going to give any legal advice and we're not going to give any tax advice. That's not the purpose. Anything you hear here, you need to go out and do your own research and find out if it, might be something that you want to do. So, one of the things I want to share with you this evening is, one of our hosts that's been hosting this call for quite some time. Most of you know who I'm talking about. He's on here. He's shared a lot of really great information with us, and again, that's what this is. We're going to share some information, and hopefully it'll educate you. It'll be informational, or you can use it as recreational, whatever you want to do. But some of you know and have heard him say on this call that he had 4 grand juries. They were all coming after him. They were coming after him real hot and real heavy. And his administrative remedy that he used quite successfully all the way to the Supreme Court was an abatement. And we found out today, and we have firsthand information, that the CID agent who was apparently coming after him for all that time has lost his job. And he's been terminated, and so he can't hide behind that bond any longer. And it's also my understanding that he's under criminal investigation. So that's pretty interesting. And we've always said it's not the man, it's not the woman, it's not the process, but it's the man or the woman that's putting forth the process. So what might work for one person may not necessarily work for someone else. So that having been said, that one of the topics we're going to talk tonight about is I always heard that 3 of the most powerful words in our community that we can use out there is accepted for value. Well, apparently there's 3 new words that blend in very nicely with those 3, and that's called a ratification of commencement. And you can connect that to the real party in interest. And you can find that Rule 17 of the Federal and State Rules of Civil Procedure. And I'm going to go ahead, and I got an email today with some pretty interesting information from a man who's, in my mind's eye, they're attacking him because he's talking a lot of truth. And apparently he's, who knows? I don't know. I'm not going to speculate. I just know that I've heard him speak. I've met him, and he's always been a warm, gentle, loving man to the people that I was around, always willing to help, never asked for a dime from anybody in terms of the help that he's given. And so until I hear otherwise, I'm going to hold the man in the honorable position that he certainly has kept with me. And in this email, I'm not going to read it all, but I'll just tell you that back in January in Vegas, he was meeting with about 75 people. And in that meeting, it was typically scheduled. It was a bi-monthly kind of thing. And the emphasis was, using caution if you were going to attempt the 1099 tax process. And, they were teaching to make sure that if you were going to do that, use that method, that you were using it, for its proper intention and the correct way of doing it, and that you could also defend it. Along with that, apparently they looked at various ways to deal with different court procedures that came up as a topic as well. And excuse me. And what they did there with all those folks is they kind of play rolled back and forth. And one guy would kind of play a judge, I guess, and another guy would play a prosecutor, and they got some volunteers from the audience to participate. And one of the volunteers apparently was from Hawaii, and who we feel that this might be, you know, a missing link to some of our processes. And the reason he was to say that in his email, because what he was doing is he was, you know, as he was being arraigned, apparently this one volunteer who decided to play the you know, as one of the guys that was in the court there, the judge was arraigning him and asked him to enter a plea. And he replied, Your Honor, I object, and there has been no ratification and commencement. And in the matter, because of that, I cannot enter a plea. Now, what happened there is that this guy, you know, has been around the community for a long, long time, and that really just threw him for a loop, because he had never actually heard it said in that way. And so that immediately caused all of them to, you know, start to research and understand how important those three words were. So as they went on, what happened was, it was pretty fascinating, but it stunned a revelation of this rule and its impact on cases around the country. And again, he goes on to say that, you know, he's been a big supporter of the accepted for value and asking for claims, and has filed, you know, affidavits of specific negative averments and on Rule 9 and which is Rule 9 A and B, and the varying degrees of success and failure with being able to do that. Because, you know, how often do we hear where people go into court cases and you know, they'll use you know, is there anybody here that has a claim against me? And if there's no claim, then obviously how could relief be granted? Well, you know, we all know that all crimes are commercial, and so, you know, one of the things that happens within that is, you know, how can the state or how could the United States be damaged? Well, we know that they can. So, you know, it's always a matter of, you know, breaking down whether they can get subject matter jurisdiction, and, you know, we have to volunteer, and, you know, we understand that. So the objection used, and by the way, there was a guy that was preparing this, and the objection was for lack of ratification of commencement. And then, because their friend, apparently, they had actually used this in a real case, and just days after meeting in Vegas, the federal warrant issued in December of last year, where this guy was incarcerated and waiting the next moves of the government, when this man filed the pleading. And 2 hours after the pleading was filed, and again, I believe this was in Hawaii, the judge in the case called a hearing, and they recalled the warrant, and they ordered the man released from jail. And then when he was released, they took him somewhere and let him go out at a convenience store somewhere, you know, in Hawaii. So pretty fascinating. So you know, in the analysis of this whole thing, in the definitions, and you know, this particular gentleman who's writing this email started researching all this, and again, if you go to Rule 17A, the real parties in interest, if you go look that up, it's right there, that every action shall be prosecuted in the name of the real party in interest, is what it says. And an executor, administrator, guardian, bailee, trustee of an express trust, a party with whom or in whose name a contract has been made for the benefit of another, or a party authorized by statute may sue in that person's own name without joining the party for whose benefit the action is brought. And when a statute of the United States so provides, an action for the use or benefit of another shall be brought in the name of the United States. So it goes on to say that no action shall be dismissed on the ground that it was not prosecuted in the name of the real party in interest until a reasonable time has been allowed after objection for ratification of commencement of the action by or joiner or substitute of the real party in interest. And such ratification, joiner, and substitute shall have the same effect as if action has been commenced in the name of the real party in interest. So, you know, what's that rule really saying? Well, it's saying that no action shall be dismissed after objection. So for the ratification of commencement of the action of the real party in interest, what is a ratification of commencement? Well, break it down, it's a claim. And if no one has a claim in government, they've told us that every time. So they can have a claim. They are neither injured nor they're trespassed. So, it's it's going to make it pretty difficult for them to get around this. And it's interesting. This is I guess this has been around for quite some time, and it seems to be pretty powerful stuff. And before we go any further, I'd like to. I don't know how many folks we've got on the call tonight, but we have a family that I think's on the call tonight, and the last name is Ward, and apparently the Ward family is being attacked. I believe they're in South Dakota, and they're asking if anybody might be able to help them. I believe they have a hearing tomorrow, and I believe that the gentleman who wrote this email, and we'll get this email out, by the way. We can get, if you get back to the person who got you on this call, we can give you this email that'll explain. It's about 4 pages here of the ratification of commencement. And anyway, this family, there's a mom and a dad, and I believe there's 8 children, and Mr. Ward is a pastor, and they're working hard and can barely make ends meet as it is now, and apparently the state is attacking them, and it's all over. I believe what they shared with me was something about a sales tax issue. And anyway, if anybody's on the the call tonight who would like to reach out to these folks, it would be very much appreciated. They have an email here, and I'll go ahead and share it. They told me I could do that. And anybody who would like to email them to get involved, and I'd really summons anybody here on the call tonight that could reach out and talk to this family and give them, if anything, some encouragement. Maybe you have a situation where you dealt, or somebody dealt with a sales tax issue, and you can share some experience in that area. Again, they're not asking for legal advice. They're just asking, and they're not asking for any tax advice. They're just asking for anybody out there that might be able to help and educate them and provide them some information. And their email address is F like Flanagan, L like Larry, E as in Echo, C as in Charlie, H as in Henry, A as in Alta, and S as in Sam, and that's 12. So it's Fletchus12, FLECHAS12 @gmail.com. So if any of you would reach out to these family, that would be really great. Also wanted to let me just do one thing here. Sorry about the ringing in the background, guys. I can't turn it off, so it'll stop here in a second. I got a call from someone here the other day too. It's a 1099 issue, the OID issue, for some of you that are involved in that. I know some of you are. And apparently this particular client was a client of a company out in California, many of you know about. And apparently their stuff they didn't feel it was done to the satisfaction that they wanted. And so they redid it, and they fixed it. and apparently I have it from a very reliable source that 2 or 3 days ago that OID was funded for them. So there apparently are success stories still coming in on the OID program. So, again, for those of you that are involved with that, if you're going to do that, you want to make sure you know what you're doing, understand what you're doing, and if it's ever challenged, you can tell them exactly why you're doing it and how you're doing it and why it's applicable to your life. We've invited a couple of guys to come on tonight as well, and they've got a couple of topics that they are, I guess you would call, kind of experts. And I don't know if they're experts or not, but I think they know a lot about a topic. And so it sounded real interesting, so we thought we'd invite them to the call tonight. And so I'm going to ask Matthew if he can unmute our friends and brothers. I think they're in North Georgia. And
go ahead
so
and have them hit *8, and then it'll pop up on my screen here. Okay,
great. Hey guys, if you heard that, if you'll hit *8, and that'll pop up on Matthew's screen, and he can unmute you, and maybe you guys would come on for a couple of minutes here and share with us what some wisdom and some information that you'd like to share with us. Derek, are you there?
I am here.
So how you doing there?
All right. How you doing?
We're doing great. Can you hear us okay?
Yeah, just great.
Okay, great. You're coming in a little fuzzy there. Can you go ahead and say something there to make sure that we've got you coming in loud and clear?
Okay. My name is Robert, and I assume that we're going to, I don't know if anybody's familiar with the
Derek?
Yeah.
Derek?
Yeah, can you hear me?
Okay, now I can hear you. Now you're coming in really clear. There you go.
Well, this is Derek. Okay. That was Robert. He was on his own phone. Okay, how about now? Am I okay?
Okay, Robert's real fuzzy. So could you go ahead, okay. Derek, and are you guys together?
Well, we're in the same house, yeah.
Okay, great. Well, maybe he could use your phone because his is real fuzzy.
Okay.
So if you go ahead, Derek, or whichever one of you wants to go first, but if you use Derek's cell phone, you're coming in much better. Go ahead.
Yeah, hello?
There you go. Now you're sounding good. Thanks.
Okay, I'm on Derek's phone. Okay.
You're Robert, and you're on Derek's phone. Okay, we got it.
Right. I'm not sure if there's a lot of people that actually understand what it is they're saying. That a lot of people are getting up speaking Obama and all of these people on Wall Street, and they mention they're trying to tell you what they've done, but nobody gets it. The reason that we know nobody gets it is because we found out that whenever you purchase a house or a car or whenever you do a credit card, they sever that relationship with you. That banking relationship that was initially started, they sever it once they do what they're doing. And the reality is...
Can you expound on that for just a minute, Robert? In other words, if someone's listening on here, they may not totally get that. So you buy a house.
It used to be you buy a house, your relationship is with the banker and yourself.
Right.
The banker says, what we're going to do is you're going to issue a note, a promissory note. We're going to honor that promissory note, pretty much like a car. You've seen a Western, a card game, and the guy walks in, he says, well, I don't have any more money, but I'm good for it, so I'm going to write a promissory note. And I say, yeah, come on, get in the game. That's pretty much what happens when you initially buy a house. But there's a relationship. There is a valid relationship between you and the bank. Once the elements of that particular instrument is violated, then there's no more relationship.
Right. Okay, so that would be one of the reasons that they don't respond to anything that we send them.
Well, sort of, kind of. Well, what happens is most everything that is placed on any financial ledger can only be an asset. Notice how they're calling everything an asset. Well, anything that's not an asset has to be stricken from the books within 3 months. They teach that
right.
in Accounting 101. And so what they do is they've turned debts into assets. So what they've done is they've taken your original agreement and they've used your name because you sign your name in blank form. People have a blank endorsement. People have to realize whenever you sign with a blank endorsement, you allow the next person to use your document with your signature on it. Anyway, you're telling them to. That's why you have to understand the elements of banking. People apparently, in the 30s, there were more people on average that did business with banks and bought houses. They understood what these elements were. And that was one of the reasons that they called it a run on the bank. It really wasn't a run on the bank. There was a formal process where if you presented your paper money to the bank and the bank couldn't honor that money, they had 3 days to honor that. If they didn't honor in 3 days, then you could close the bank. You could literally shut the bank down even after they honored you because they dishonored you initially, and that says your community cannot be supported by that particular business.
That's right. That's correct.
So what they're doing now is they're simply remember, everything that we're dealing with now is strictly debt. It's not to say that that's wrong. What it says is they've gone too far. What the 30s were about was exactly the same thing that's happening now, but it's combined maybe 100-fold. But exactly the same thing that was going on in the 30s, which was speculation, greed, and turning debt into assets.
Well, yeah, and if you think about it for a minute, if you go back and you study history, which unfortunately a lot of people don't do, they don't realize what actually took place in 1913 and, off the coast of Jekyll Island, in the creature of Jekyll Island, and where the Federal Reserve was conceptualized, and then 10 years later, during the Christmas holidays, they signed the Federal Reserve into taking over the monetary system in America, and so in came the central bankers, and in came the Federal Reserve, which is obviously the private banking. But think about that. I always ask people, well, they called it the Roaring '20s. Do you know why they called it the Roaring '20s?
Yeah, we've kind of gotten away from that, and we realize that because they are doing what they're doing, they need the Federal Reserve. The Federal Reserve is more of a political machine than a banker's machine.
Well, yeah, but my point is that the Roaring '20s were where America was thriving. People were coming to America. They were coming to fulfill their dreams. They were using money. Money was backed by substance then, and they were saving. None of the people in the 20s didn't go out and buy crap that they didn't need with money they didn't have to try to impress people that they don't know.
Yeah,
that wasn't the mindset back then. They were starting a business, and they were working hard at that business, and they were keeping the money, and then they were taking their own money and reinvesting it back into themselves. They weren't borrowing it from banks.
Right, but the problem, if there is a problem in this, the problem is that everybody has become consumers, and you're partly right in that back then most people did their own thing. It's not a matter of them having a formal relationship with a bank more than having a formal relationship with themselves by saying, you know what, I want an apple. So let me buy some seeds and plant an apple tree in my yard. We don't do that anymore.
Right.
And what happened is we go to buy an apple, no matter if it's at a health food store or not. We think that we're buying an apple. We're doing more than that.
Right. People don't realize today that when they buy an apple, that they're raising inflation.
Well, what you're doing is you actually, when you buy that apple, you're not only supporting the place that you purchased it from, you're supporting the farmer who grew the apple, you're supporting the guy who actually the farmer bought gas from, you're supporting the police department. Whenever you do the things that we're doing, the system that we have has to be in place. Period. Right. And whenever they talk about production, they're actually talking about your will to actually not grow anything yourself, not produce anything yourself, but depend on someone else to do it. Once you do that, that's when you really open things up so that you need a Federal Reserve. So
okay, so what I think what our listeners might be interested in finding out is, so they've done the loan, and then there's the separation between the creditor and the debtor-lender relationship.
Right. Now, well, what happens then is you actually are detached from that financial obligation that you were attached to. So then what you have to do is realize what you are in the system, which is a consumer. It's not actually the creditor that has the power. It's the consumer that has the power. Because remember, everybody says there's no funds. So now it's the consumer's ability to say this needs validating. And this would be a lawless country if they didn't have in place something so that you would be able to validate any business transaction as a consumer. So they have validation systems set up for everything, including homes.
I'm a little confused, and that doesn't mean that our listeners are, but right, I'm confused because I
okay, well, what we have.
You were going to tie in the relationship between the creditor and the debtor, and how you can reestablish that relationship. So now they have to listen to your demands.
Well, you really
through the UCC1.
Right. You really are not establishing a relationship, because once that tie is severed, say for instance you bought a house from a banker, the banker actually changed the elements of the instrument that you went into contract with. So now what you have to do is you have to realize where you are in the puzzle, and the way you do that is a simple sending a letter to the person, to the company that you're paying, and you're asking them for the accounting. What am I saying?
In the transactional relationship, when you were saying that they terminated it, right, with the change it to a bond, you still have to remember we got to go back and reestablish that there is something there.
Right. It's assumed now, because you're paying the mortgage, that you're actually engaged in a relationship with them. So your relationship to the property or to the mortgage is only an assumed relationship. When you do the UCC1 to say that, yes, I'm the debtor, and this is the original creditor, now you have established a real security relationship in your property again.
Okay, so let me back up here. Let's chunk this out so people that maybe not be at a level of a certain understanding can grasp this. You're going to go back to the bank, and you're going to send them a letter telling them that you understand that you're the lender. that they're the debtor.
Well, wait 1 second, Dave. In the way that we approach this thing is slightly different from the way that a lot of people in the Patriot or the commercial movement is doing it. We're actually approaching it simply from a standpoint that the original relationship was the borrower, i.e. the homeowner, was the debtor, and the loan servicer is the creditor. Now I'm going to tell you why we're doing it that way. We're only doing it that way to tie them back to the laws that govern them. When we hadn't quite figured out how to operate like you guys, I think, have been operating. Okay, you guys have figured out the creditor, making the homeowner the creditor, and the actual loan servicer or the trust the debtor, because it's exactly right. You will have issued the documents that they have created the funds from. We do understand that. But before we get to that, we want to hold their feet to the fire for what they actually said that they were in the beginning, i.e. the loaner, the lender. You understand what we're saying?
Okay, so, let me make sure I understand. So you're saying is we understand our position. Our position is we're the lender, we're the creator of the credit, and we signed the note. That funded the loan, but it wasn't a loan at all, because what it really was is a financial investment contract on their part, whereas they sold it, bundled it, made interest off it, marketed it on Wall Street, on and on and on and on and on. So that's the truth. That's what actually happens.
That's
so
correct.
If I'm understanding you correctly, you're just coming back and say, okay, but what we're going to tell them is that we're going to let them think that they're still the lender, and we're coming at them as the debtor with this letter so that we can set up what with the UCC1.
Okay, now, Dave, this is Tina. Can I jump in here for a second? Just to throw a different way to look at it. And this is something that I've used to explain the whole concept with the A as well. There's actually two transactions going on here, just like there is with the mortgage and the note. You've got two separate things. In the instant with the note, we are the creditor. In the instant with the mortgage, we are the debtor. When they take you to court to foreclose on you, they're coming after you for the mortgage, not for the note. So what we're doing is we're reestablishing that connection based on the conversation that I had with Eric last night. We're reestablishing that connection dealing with the mortgage, because that's what they're coming after you for, but even though the two are tied together.
Okay.
But they're two separate transactions.
All right. I understand that. Okay.
Hand, we start at the top of the pyramid as the creditor, and the bank is borrowing money from us, which is what we're doing with the original A when we file it. But then when they loan us back our own money, they are the creditor and we're the debtor now, because we voluntarily enter into a contract with them to become the debtor of our own funds. So that's what we're dealing with, is that second transaction right there.
Okay, and to clarify so everybody understood what you said, the A, you're talking about the 1099-A.
Yes.
Okay. All right. So that makes sense. I buy into that. So what is the remedy? What can someone gain by doing this letter and this UCC1? If you can kind of tell our listeners what that's about.
Well, what they have to do is, of course, what we found out was actually in the UCC manual itself. And apparently the way they have it set up is just like you would actually want to know what's on your documents for, say, a credit bureau. You're supposed to actually do that with your house also. 2 times a year, you're supposed to actually ask for an accounting. Because we know that they have securitized it, we know that they have a problem with the accounting. But some people it was just lousy paperwork. They don't know where the paperwork is. So when you do an account, when you ask them for a statement of accounting, then they don't respond within a given period of time. Then what you do is you issue a document telling them to sever their security relationship with that property.
Okay, so let me back up. What's the first step that you have to do for this process? You're talking about
the first step you have to do is you have to establish that you have a security interest, not the security interest, but a security interest in the property. You do that by doing a UCC-1, establishing your original relationship. Once you do that, and of course, through this whole process, you're going to have the Secretary of State to actually send the document to whatever company you're dealing with. You wouldn't be sending this yourself. You want the state to send it, because with the state sending it, it's automatic validation.
Okay, so when you say the state, are you talking about
the UCC office? Whenever you do a UCC-1 or any UCC document, you can actually have the office send it to whatever company you want it to go to or person. By doing that, you're having the state, typically the UCC office is under the Secretary of State. I know it is in Georgia. So when you do that, you're actually having the state to issue this document to send this document to them.
Now, Rob, you got to remember.
Okay, so let me ask you this: have you guys done this?
We have had a couple of people to actually send it. What we did early on, before we figured it out, was we figured out that whenever they do a service or change the servicer for the account that they say they have, then you have a certain amount of time.
You mean when you say change servicer, where they've sold it?
Yeah, well, they've actually moved it to another company, and they maybe moved your house from one pool to another pool.
Okay,
and so they may change the servicer for that, or they may change the servicer simply because the servicer wants to make some money, and some other servicer wants to make money, because the people you're actually sending the money to are the people that pass it on to the trust fund. The trust fund cannot operate directly with the person who's paying the mortgage.
Right,
the principal
understood. But
right.
let me go back to the question, and that is, have you guys done this, and what was the outcome?
Oh no, we haven't done the complete process. We've only done the initial process.
The initial process. Explain to everybody. Explain what the initial process that you've done.
The initial process is just simply establishing that you do have a security interest in the property that you're in. Now, when I sent them a certified written request, they ended up not sending me anything back, which meant that they don't have any documentation. I don't know what they did with it, whether they lost it. So by knowing that, I know that if I go through this process, what I have to do then is do the final step, tell them to separate themselves from the property. And then if they don't, then what I do is then I have to take them to court.
You have to take them. So you're going to take them into equity court.
You would have to take them into court, but what you've done is you've actually let the state validate everything you've done by going through the UCC office.
Okay, but what's to say that the judge won't roll over, even though that the state ruled on it? You're asking the judge to rule against, his pension where his pension is.
Okay, you're right. Now, this is Derek on. You're right. We are asking the judge to rule against his pension, and that's when we come in and we make sure we pull his bonds. We make sure we've actually developed a pretty good relationship with the Office of Risk Management here in Georgia. We actually send emails. He sends us all the risk management insurance policies that we want. You know, we get all their oaths. We make sure that we have everything that we need. Then we do a mandatory judicial notice when we go into court. Now, we've not done that in regards to the financial transactions we've done, but we have done it on a DUI case, and we've done it on traffic instances we've gone through.
Let me back up and ask you one component about your process. You say you sent this certified. Are you doing this under a notary seal?
Okay, here's where it is, okay? Remember when Robert was saying you do it through the UCC office? What he's not telling you is when you file your UCC-1 and you file it with the Secretary of State, on that document, you have an option of actually letting the Secretary of State actually mailing a copy of your filing to whomever you want to. And one of the people you want to mail it to through the UCC filing office is to the creditor or debtor, whatever relationship you have. You let the Secretary of State through the UCC filing office send it to them. And that
are they going to request a forensic accounting of everything?
No, that's what you're going to do. You're going to do it under 9-210, which is the code, and it's the request for accounting and request regarding a list of collateral or a statement of accounts. Okay.
Say that again. It's 9- what?
It's 9-210.
Okay.
It's under the secure transactions of the code. Okay. Once you've done that, okay, you also need to look at 9-509, which actually tells you who has the authority to actually file a financing statement. Okay. Now here's the details of how they don't want to answer any of the qualified written requests that a lot of us have tried to do and they just ignored us. Right. The reason they ignored us is because, one, they have terminated the initial transactional relationship. So really, you're not a party of interest as far as they're concerned. All they're concerned about is the trust. And as Tina was telling me last night, you all have also discovered that they're basically operating this thing out of a gifting thing. So they're treating your payments every month as a gift. We don't know why. Well, the reason why is because they terminated the initial relationship. So under 9-509, it states simply that the debtor has to give explicit authorization for the creditor to file a security interest or a financing statement. So, but then it's the creditor's option not to file it. The reason being is that they don't have to answer your questions if they don't file the financing statement.
Okay, so what you're doing, so what you're doing here, if I'm understanding you correctly, is you're setting them up for the kill shot. And the kill shot's going to, so you're setting them up for the kill shot, and you're doing that by way of UCC-1. You're using the state who's requesting it on your behalf.
Yes.
And then once they don't respond, how are you getting the ball into the end zone? Is you're relying though upon the court?
No. You're not going to court yet. You're not going to court yet. You've got to finish the actual process that's defined in the secure transaction section of the code. And it's really simple. It's very similar to the way that you do a default through the notarial protest, but it's not the same way. They have once you do a request for accounting, the 9-210, they got 14 days to respond.
The question is, can I ask this? This is Steve. Are you sending that under a notarial seal?
No, the Secretary of State is the notary. She's the supreme notary of your state.
But Derek, the question is, when you actually send them the request for accounting, are you sending that through the Secretary of State, the request for accounting, or are you sending that yourself?
No, I'm sending that through the Secretary of State also.
The Secretary of State is sending that as well. That's better than a notary.
Yes. I'm filing that with the UCC-1 financing statement because once I establish the initial relationship with the filing of the UCC-1, stating that they are the creditor, I'm the debtor, I'm also going to file a second financing statement on my document, on my request for accounting.
Okay, so what in some part here, we're relying upon the Secretary of State, who is the ultimate notary, obviously, to send them this request. What makes us think that the Secretary of State's even going to do this?
Okay. What makes us think that they're going to do this is, hold on one second.
You saw this question coming, didn't you?
Oh, of course I did. I've been dealing with this for a second.
I'm sure other people are going to want to know a couple things as you're looking that out. Number one, how long would this particular process take? And then, and it doesn't sound like it's an expensive process. It doesn't sound like it's hard, to do. But I'm sure it's not easy either, because you got to cross all your T's and dot all your I's.
Exactly.
All UCC is out of the Secretary of State, by the way, in every state.
Right.
What did you? I'm sorry, I missed that, Stephen.
I said every Secretary of State runs the Uniform Commercial Code. Yeah, absolutely. That's a beautiful thing there. Okay, so again, what's this going to get somebody? I mean, obviously, I think I know the answer, but I'd like to hear you say it.
You said, what is it going to get you?
Yeah.
It's going to get you what's known as a termination statement, okay? Eventually, when you get done sending them the request, they don't answer in 14 days because they don't want to answer. They don't want to tell you about the securities that they've created. They don't want to tell you about the excessive funds they've created because technically they think that you don't have a right to it. What it's going to get you is the right to file a termination statement. When you file that termination statement, you are now saying that they have no right to this property because they have dishonored you. And once you have done that, you now have a right under the code to go and attack them for fraud, which is the mail fraud, and also with criminal charges. And for each count that they don't actually answer, there is a set penalty in the UCC that they must actually conform to.
Don't forget, now they have to prove their security.
Right. Then at that point, they have to prove their security interest.
Because you already have that in place.
Right.
Well, we know they can't.
Right. So now what they've done is they've defrauded. Now they've actually committed a crime.
Well, yeah. Well, we know they're committing a crime.
We know this, but now you have proof that they've committed a crime.
Okay.
Just to back up, the way that we got started with this conversation yesterday, Dave, was we were talking about the declaratory or the default judgments, and this is just an alternate. Because how Derek and I got on this conversation is because when we send the banks letters, if we get a response at all, it's bogus. I mean, it's the responses that I get back from these declaratory judgments that we're doing, they're laughable. I mean, they'll even go as far as to the point to say, and they'll point by point rebut what we're saying, and they'll say it's under penalty of perjury, but they won't sign it under notary seal. So it's laughable what they do, and so this is just an alternate way that might even be more time efficient than a full-blown declaratory judgment, especially for those of you who are having a hard time finding notaries in order to do the declaratory judgment process for you. This is a way to utilize the Secretary of State locally in the UCC process in order to get the same means of attempting to get the equitable accounting.
Right. I want to read the commentary for the termination statement, which is 9-513 in the code. Okay, and it says
again 9- what?
9-513. 513.
Okay.
It's and the title of the code is the title of that section is called termination statement. Okay, and the commentary says this section specifies when a secured party must cause the secured party. Okay. Now I'm going to make sure you understand the distinction between the two. Once you have come and filed the UCC-1 establishing that you have a relationship, you become a secured party. They remain the secured party because they allege that they are the creditors. Okay? So now it says this section specifies when a secured party must cause the secured party of record to file or send the debtor a termination statement. for a financing statement, because most financing statements expire in 5 years unless a continuation statement is filed, Section 9-515. No compulsion is placed on the secured party to file a termination statement unless demanded by the debtor, except in the case of consumer goods. Now, in the code, it actually tells you that anything that is a household or household goods is considered consumer goods. Okay, because many consumers will not realize the importance to them of clearing the public record, an affirmative duty is put on the secured party in that case. But many purchase money security interests in consumer goods will not be filed, except for motor vehicles.
Okay.
And the only reason they say that for motor vehicles is that your certificate of title operates as a UCC-1 financing statement in every state. That's what it's
right. And we were talking about MSOs this morning. So, and they not wanting in the dealerships not giving those up.
Right. Because they don't want to give those up.
Well, if they give that up, you know, you can basically tool around and you can move about the country. And guess
Absolutely.
what? You don't need any tags. That's of course that's another topic for another call. So, all right. So bring us up to speed, guys. You know, where are you with this, and how far are you from getting the ball in the end zone?
Well, the studying we've done this past year, we wanted to make sure we really understood this before we actually started running after them. We didn't want to start, you know, kind of jumping out there and you know, dropping kittens on the way. So we are actually, Robin and I both are probably going to be starting the next month or so, getting this ball rolling.
Okay, so I'm just curious, what's holding you back from starting yesterday?
Me working every day. Me working every day, trying to get a professional engineering license and all the kind of other BS that I got going on in my normal life, trying to pay the bills.
Right. Okay.
That's what's holding me back.
Is there anybody that can? I mean, you have a mortgage, I assume, right?
Yeah, I have a mortgage, and also, you know, I cut my hand off 3 years ago, or actually in 2005. So I'm still doing recovery from all that, you know, and I can't do a lot of typing at one time in one sitting. So I've got a lot of little issues that I'm dealing with myself.
So what if somebody was on this call tonight that would help you and assist you to move this along? Because this sounds like, you know, something that people could use fairly quickly and, you know, save their home.
This is Matthew. I'll help out.
Oh, yeah, I'm game, yes.
Well, then, you know, because, you know, you're on a call here you got a lot of people on here that are really brilliant, and they're wonderful, amazing souls who they're all looking for remedies. A lot of the people, you know, they're just trying to help other people too. So, you know, and a lot of people on this call, as you know, there's most people operate from, you know, they make a decision one of two reasons: inspiration or desperation. So, you know, a lot of the people, you know, you know, and that's just the way it is. So, you know, there's lots of people on here that can type, man. So,
okay.
If you want to put anything out on the call tonight where some of these folks can contact you and help you, like Matthew just said, man, he'll help. And I know there's probably other people on here. I'm getting Skypes from people that are saying, I'm in. You know, throw me in the mix.
Let me interject too. Here's something I absolutely love about this process. A lot of the things that we have been talking about are more advanced. You have to be very secure with who you are. You have to know who you are as a secured party creditor. Whereas what Derek and Robert are dealing with it's completely inside the box. You're not stepping outside, so it's not a lot of the stuff that I'm working with clients. There's a lot of homework involved to get you to the point that you can stand behind your paperwork and understand what you're doing. Whereas what this is, if you're filing the UCC-1 as the debtor just to reestablish that relationship and put them in a position where now they either have to answer through the Secretary of State for the accounting, or it puts them in a default position. You're not stepping quite as far outside the box until you get to that point, because it does take time. And a lot of people don't have 2 years to sit down and study full time. So I think this is, if we can work together as a team, I think this might be a viable remedy for some of the more beginning people that aren't able to get to that secured party creditor position just quite yet, but they need the help now.
Right, exactly. And it's amazing, man. You ought to see my screen is lighting up here like crazy. Jimmy put in here, he said, I'll help you 4 times, make that 8. Okay, make it 10 times.
This is Robert again, too. And the key to this was us understanding exactly how it works.
Right. Well, here's what you're doing. Here's the beauty. Look, they've created a fraud. They've created one gigantic lie. And so guess what? If you stop and you analyze that, there's always a way to penetrate it.
Yeah.
Why? Because the truth and the light will always break through the dark and the lie. So you guys have done that, and that's the beauty of what you're talking about here.
Right. And the other beautiful thing is when you send all of your requests for accounting and you send the termination statement to them, you're not sending the termination statement saying you better terminate. You're actually sending the termination statement with the evidence that you've already gathered, and they haven't responded, and they're breaking the law when they don't respond. You're telling them to go ahead and sever their relationship that they say they have, because you are now established as a secure party.
Can I just interject here? This is Steve. I remember the Steve from Texas bringing up the fact about calling this lady at the FDIC about the call report. Well, I did that, and I wanted to let people know that I did this, and the call report I was trying to find was Chase Home Finance. Well, that's just the division of J.P. Morgan Chase and Company. So there is no call reports for these individual mortgage bankers because it all lies in the principal company. So, for example, Citibank or Citicorp, that would be the call report. I still have not peeled onion on getting what's actually in that call report, but in the call report will show that they can't lend anything because it's in their charter. The banks can't lend anything. So that's another tool that can be added to the request of the statement of accounting.
Is that what? Are you talking about the S3? Is that what you're talking about?
Well, the S3 is it's the call report. The call report is something they have to do if I understand it correctly, on a quarterly basis. They have to submit to the Securities and Exchange Commission or the FDIC and let them know exactly. If you go in and type, I did this, and it shows all what has to be on a call report, and it's showing their assets, their liabilities, etc. Well, they're not going to show any assets that are loans because they don't make any loans. They go to the TTNL account, which is the Treasury Tax and Loan, and take our credit. That's why we got to send the 1099-A if you're doing that. So we abandoned it.
Right. Well, in our case, it would be acquisition.
Right.
Yeah, because then you're not checking box 5 as yes, you're checking it as no.
Well, actually, I just let you know, I'd check yes. They are liable for repaying me. I will give them an option. They can credit my account, but if they don't credit my account, that's what sets me up to utilize the OID in certain cases.
Well, I had heard.
We do it in everyone.
I heard that you can send that along with a demand letter that says I've checked the box no, allowing you to return the funds without. I forget how the letter was written, but I think you know what I'm saying there. But if you don't return it, then I'm going to go ahead and report it. The suspicious activity, the 3949A, the whole 9 yards behind that. You guys. Well, this is really interesting. So I think what I'd like to do is there's another topic I want to talk to people tonight. Something that people can do right now, immediate. And I've got a success story to share with you about doing it. And I want to thank Derek and Robert for being on here tonight. And, obviously we've got a whole bunch of people here that have sent me, again, my screen is lighting up from Skype requests. So Derek, however you guys want to do that. If you want to put your information out here on the call tonight, you're welcome to do that. If you're not comfortable with that, you can certainly give, people on this call, you can get that information to them, and then we can, get it out to the other callers. How would you guys like to play that out?
We'll go through Tina. We'll give our information.
Okay, that's good. Yeah, that'll work. And then Tina can, share it with others, and we'll take it that way. So, anyway, very interesting. Obviously, very, very brilliant idea. So stay on it. But we want to help you to move this along because there's people just getting their asses handed to them, as you well know. And if this is something that people could do within a couple of weeks' time and save their property, I mean, you can throw your house into bankruptcy and buy some time if you have to. And if you can come back with this process, and we're not going to hold you to this, but I do have one question. Once you've got this pretty well perfected, what do you think the timeline is on it?
Well, actually, the timeline is not set by us. The timeline for this is actually set by the code itself. Now, the timeline is going to come in when you go in and you actually take them to court. Because all you're doing in the beginning is just simply gathering evidence, and we found out through our research that once you do certain things and the state validates it, Secretary of State validates it, then it's irrefutable because it's the government.
Right. Well, but the thing about it is you may want to put that in federal court. One of the things that we're working on right now is that we're studying pretty intensely is a Liz Pendens process, and there's talk of how that's working is through the federal court, and we'll save that for another call as well. But okay, well I see what you're saying. So it can take a while, but if you had to take a guess based on what you talking there,
Well, with just the UCC process in and of itself, it gives you timelines as to when they're going to answer, and it all depends on how fast that you can send the next step to them. The last step to the UCC process is presenting them with a termination statement. That's it, with gathering the evidence through the UCC and becoming a secured party.
Okay.
Right. Now,
well, again, go ahead.
Now, when you go to court, there's several things that actually makes the evidence stand pretty much on itself. And that one of those things is a mandatory judicial notice. Not a judicial notice. It's a separate thing. With a mandatory judicial notice, the judge is not the determining factor on whether or not the notice stays in the record. With a mandatory judicial notice, the judge is notified that they are being noticed. They have nothing to do with that notice staying in the record.
Okay. Well, it would make sense to me though that you put it in a court of record because you got a lot less.
Well, you actually should go to the Superior Court, because the state court is not a court of record, not technically, because it's an administrative court.
I'm saying put it in a federal court, a federal district court.
Oh, yeah. Well, yeah. We've not dealt on the federal level, just the local level. So, yeah, that's an option.
Okay.
And I'm not sure how fast the federal system would move it. Just on a local level, it would seem to move faster.
No, I would just say, just from what Dave is saying, you want to do it on the federal level because a bank is federal. They're you look at how they operate, they're federal.
Okay.
If it's a state bank,
mm-hmm.
If it's a state chartered bank, then you might want to do a state chartered, go on the state court. But if it's a federal bank, they are regulated. They're under a federal charter.
Right.
That's why it says NA after it. HSBC Bank NA. That's National Association.
Yep, that's correct. Well, I'm sure that should be just one of the components to get figured out. So, Again, if you'll get your information over there, guys, that was great. Thanks for sharing your wisdom with us and your research. And I know the kind of time that's involved in researching something like this. So it was great having you here. So one of the things I'd like to talk about, and it's kind of interesting that these guys just kind of mentioned it, and it's called termination. And I'm just going to share something that I did. And again, it's up to you guys if you think this is something you might want to use. But I'm just going to share something that I did that worked, that has worked. And then I also know some other people that this worked for. If you go read your loan docs, you'll see that you are the grantor. And as the grantor, if you go read your deeds of trust, or if you go read your documents that you have on your mortgage and such, you'll see that almost all of them, the bank assigns a trustee and a beneficiary. Well, that trustee and beneficiary are more often than not an attorney or a law firm. And it kind of goes unnoticed. They're just sitting there, and of course they're sitting there waiting to jump on you. Might you go into this alleged default, and then they use that attorney and those people to come after you in the foreclosure proceedings. So if you do a little research in your state, and you have to do that, I don't have the information on that, but I can tell you in a judicial state where, for example, they have to go to unlawful detainer. What you can do in a state like that is you can go in there and you can do what's called a trustee termination document. And basically what you do is you go in there and you fire and you terminate the trustee and the beneficiary. And then you reassign a new trustee and a new beneficiary. And I'll share with you a story. I had a guy call me here within the last couple of weeks. And they did that. And the guy was facing foreclosure. He was 3 days away from the courthouse steps. And they went in and they filled out the trustee termination document, and they went in to put it into the county record. Well, they have one of those typical county-type recorders who won't let you file anything. Well, again, we could probably talk for hours how to deal with those kind of folks. But this one gentleman went in and apparently raised his voice a little bit. And of course, they have a button underneath the desk there, and the next thing you know, he had some sheriffs escorting him out of the county recorder's office. So we talked after that and determined that maybe it might be a good idea to go to the next county and to just calm down, stay nice and calm and relaxed, and just get the thing recorded. Well, they did. They got it recorded. And then the idea came up that maybe they ought to pull some certified copies of that, and then they could take those certified copies from the other county. And the guy that did it just sent me a Skype, so he's on the call. That's great. And Matthew, let's see, we may open this back up, and if he wants to say anything about that, I'd like to actually call on him to see if he'd like to talk a little bit about that. So anyway, I don't. Well, part of that process too, though, is that you take those certified copies and then you send those certified mail to all the parties. Oh wow, okay. So here I got Dan and I got Evan on here, and they're talking about they're the ones that did that and notarized them and so on. So anyway,
if you want
these
them to
guys
jump on, just have them hit *8.
Okay, guys, did you hear that? Dan and Evan, if you two guys, if you would please. If you guys would hit *8, and then Matthew can, he'll know who you are and then can unmute you, and then I'll ask you guys to talk a little bit about that. So, long story short, they postponed the foreclosure. And I believe they can come on and correct me in a minute. I'll probably ask Dan to talk first and Evan to talk second. And so it's my understanding now, too, that they've postponed that foreclosure for another month. So, it got them. It worked. Because now, if you're standing on the courthouse steps and you have certified copies out of the county recorder in the county that you're standing on the courthouse steps, and there's a sheriff there, and you have two or three people with you, friends, maybe they're notaries, and you go up and you tell the sheriff that guy over there who's standing telling that he's the trustee on this property, guess what? He's lying. Why? Because I've got a certified copy of the record right here in front of me, and I'm putting you on notice, Sheriff. You need to stop this sale because you're witnessing a crime, and if you don't stop it, I'm going to have you arrested. I'm going to arrest your bond, and I'm going to hold you fully liable for what's going on. And, of course, if you add in, again, a couple, 2 or 3 people, and you add a video camera, and you can capture it on video, that sheriff's going to have a real problem on his hand because now he's involved. He's committing a felony. Why? Because he's allowing a crime to take place, and he's an officer. He's a peace officer, and he's there to do what? To stop it. The other thing, and I'll add this to it too, even if he did ignore it, one of the things you can do along with that is if you have a couple of people show up who have some silver coin, 5 or 6, 10 pieces of silver, you will be the only ones at that foreclosure sale who have lawful money. So you can bid on the property, and then there's actually a script out there that, I know it's floating around out there, shows you exactly what to do. Tells you exactly what to say, exactly how to do it, and you can certainly do that. So, Dan, are you on the line? Okay. How about
I
Evan?
Just muted somebody that is called non-member.
Okay. Can you hear me?
There he is. There's Evan. Hey, Evan.
Hey, Dave. How are you?
Fabulous. Can you tell our listeners a little bit more about, where you guys are with that and how it worked for you?
Yeah, I sure can. And I apologize, but I missed the intro, so I don't know if I'm going to repeat anything. But basically, what we had done was exactly what you had just outlined, and we had terminated the trustee, put everybody on notice. We recorded that filing in the county. The beautiful thing is I made 4 or 5 calls to ask for a couple of witnesses to join us, and 12 people showed up, which was quite helpful because in Phoenix, in this particular scenario, they have 3 auctioneers that are all rattling off as many properties as they can, as quick as they can. So that it's a little bit of a trick to find the property that you're after to deal with it. But in any event, what we had done was we had put everybody on notice. We had certified copies of the filing that we made copies of as well to bring with us to the auction, and then basically put everybody on notice, telling them that it was off the block, and if anybody bid on that, they would be named in the ensuing litigation. Okay. Additionally, we did bring lawful money to bid on it as well, but as luck would have it, they had already postponed it for another week. Okay. And then when we inquired again a couple days prior to the postponed date, it went out another 4.5 weeks. Okay, so this is speculation, but the speculation is that the trustee and the bank are making sure they're covering their ass before they move ahead any further.
Okay.
Did you notify the sheriff too?
No, we didn't.
Would you recommend to do that?
I think that would be a good idea, particularly if you can educate the sheriff enough to get him on board with what's going on. I mean, certainly having a sheriff on your side can't hurt in those proceedings.
No, especially when there's a perceived liability on his part, because they do have to be. It's my understanding that they have to be there during the sales.
Right now, Arizona is a trust deed state, so they've set this contract up from the get-go to bypass the litigation that's commonplace to the mortgage states. So there isn't a requirement. It's not a sheriff's sale in those proceedings. Okay, this is all happening administratively.
Right. Okay. Great. Well, that's cool. Well, obviously, something now. And to back up, Evan, did you sent notifications out to the trustees and the beneficiaries that had been terminated?
Oh, correct. That was the other thing I was going to mention. The notifications went out both by registered mail and by notary fax. Okay, so when the notary
fax. Okay.
Correct. So when the notary faxes those documents and receives a what do you call it? A confirmation.
Transmittal
right,
receipt.
A transmittal confirmation.
Right.
They're served.
Yeah, because you've got the evidence of the transmittal receipt. As a matter of fact, it's interesting. I'll pop a real quick story in there. But I was talking to some folks the other night, and we were educating each other and sharing some information. And in that sharing of information, we realized with each other that it might be a good idea that if a debt collector calls you and they're harassing you, most people don't know what to do. Well, first of all, be real friendly. Lure them in. Tell them you're in a position to settle. And say, hey, all I need you to do, can you fax me a bill or an invoice or something show everything that I owe, all your fees, everything, and, can you fax it to me? And, a lot of times you'll get them to do it. And then when they fax it to you, then you turn around and, there are some debt collector letters that demand to show how you could be under some contractual obligation to pay this third-party debt collector who's bought a debt. And you put them on notice. And that letter could say things like, oh, gosh, what could we say? I don't know. I've used one that kind of said, well, do I know you? Do we have a contract? Have we ever done business? Have we ever traded services? Could you show me where I'm under some contractual obligation to pay you? Let me put you on notice. I'm telling you, never call me again, never contact me again. And if you contact me through the mail, that might constitute mail fraud. And by the way,
let's take this a step further, Dave. Here's what I do with mine.
Let me finish.
Okay, go ahead.
Well, let me just finish this one thing, and this is how I would button it down by saying, if you contact me again, you agree to the terms of my contract. And my contract is I'm going to charge you $1,500 per call per person per occurrence. Now, you have the right to leave me alone. You have the right to never contact me again. However, if you do, you agree to the terms of this contract. Then, like you just said, Evan, then you fax it to him. You get a fax transmittal sheet. You fax it to him again, showing that you faxed it to him the first time, and then turn around and send it to him certified mail. And there's probably a good possibility that you won't get bothered by them again. Go ahead, Tina.
Well, that's actually right along the lines of what I do, but instead of it being $1,500, if they attempt to contact me in any way without validation of the debt, there are specific criteria they need to meet. So any further contact with me, either by phone or mail, without full and proper validation of the debt, constitutes them wanting to contract with me. My starting bid is $100,000. It's $10,000 an hour. It's $10,000 per correspondence, either by phone or by mail. $5,000 an hour for research, and $37.50 an hour for miscellaneous time spent. And I've actually had, I recently had a debt collector send me a letter. I sent them the full validation letter. They sent me verification and turned around and slapped a lawsuit on me, which actually is funny because now their first invoice for me is for over $150,000 that I will press a declaratory judgment. You don't think that lawsuit's going to go away?
It very well could, because they're gonna test you. In fact, I talked to somebody. They called me and we were discussing one thing, sharing some information with each other, and they got a letter, and they sent them what they alleged to be the verification of the debt, which was the original application and an invoice. Well, wait a minute. Where's the contract? Where's the wedding signature agreed upon by both parties? An application is not a contract. I could send anybody an invoice. Then there's another letter that you could probably send to back up that. My point is that, people are getting harassed. They have 4 or 5 or 6 or 8, 10 credit cards and creditors, and they're in trouble, and they're getting harassed. They're getting, I know one person that was talking about getting 30, 40 calls a day. I mean, they just, these people are bottom feeding, they're insane. I mean, and they don't realize that they're calling the people next door, their grandparents, their uncles, their aunts, their cousins, their nephews. I mean, this country is just getting its ass handed to it. So it amazes me, these people. And I've known some people that try to talk reason to them, and I'm like, you know what? A leopard, you can't change a leopard's spots, so why would you even try? Hey, Dan, I know you've been sitting over there patiently waiting to say something. Are you there?
I'm here. Do you copy?
Yep. Go ahead, Dan. You got the floor.
Okay, thanks. I want to tell you guys that everything Evan said is correct. I was there next to him, alongside with him, and I notarized documents. And I want to tell you that the outpour of support in that one trustee, firing the trustee proceeding that we did was amazing. We had at least 7 or 8. How many were there, Evan, of us, meaning law merchants or commercial redemptionists from this valley?
Right, there were a dozen people that were out there backing it.
Yeah, about a dozen maybe, and they're all friends or acquaintances of Evans or mine, and we almost outnumbered the other half of the group, which were the guys running the show, which was a charade. I want to tell you, the whole thing is a charade. It felt like a slave auction in ancient Rome, something of very, very most unfair thing you've ever seen, just giving out property that doesn't belong to them, So
right.
There were 12 of us, and we put an end to it real fast, and it seemed effortless once we were underway. But I was a bit nervous at the beginning. It wasn't hard to stall them, and I think now we have enough time to to prepare for the next step. But there are many ways to handle it, and I just checked this on your screen. Dave, I saw a message about forms 28, 90, and 91, where in California they had another success with a reconveyance through MERS, which is the nominee for the beneficiary. So that's another strategy, which maybe not tonight, but at some other point we could discuss.
Yeah. Get that to me, Dan, and we'll bring that in as a topic. I really like that.
Yeah, me too. I'll tell you why I like that, because it uses GSA government forms. It's totally in the box. There's no arguing.
Right. I want to share something with you that one of my buddies down in Florida just sent me here, and he's talking about if you have a clerk and they won't record stuff in the county record. He's saying you can go put an ad in the paper and announce that clerk under their oath of office has deprived you. You just put a notice. You go and you put your local county paper and you say, hey, I just want to put a notice that such and such clerk who is under such and such. And you do a little homework. Get her oath, get her bond number, get her full name, and if you have a witness, even better. If you can go in there with a couple of witnesses and say, you know what, I'm going to give you one last chance, opportunity to cure. You're going to file my documents, and if you don't, then listen. I don't want this to be a career-changing moment for you. By the way, that's something you got to add. Because that's not threatening. You're just very nicely telling them, look, you know what? I don't want this to be a career-changing moment for you or episode. I'm giving you an opportunity to do your job. If you don't do your job, then you're going to leave. You're going to push me into a corner that the administrative remedies that I'm going to use upon you are going to be severe, and I'd hate to see you spend any time in jail. So it's up to you. You're either going to file my documents, and you're not going to obstruct justice, which is what you're doing. You're not going to deprive me of my administrative remedy, and if you do that, then unfortunately, we're going to be talking about some federal consequences here. So, that's just you got to think outside the box, and that's what's great about coming to these calls, you guys, is that there's so many things out here that people have done, and they're willing to come here and share all this information, and you can really get some great ideas. And something I want to also bring attention to, what you just heard, is that people in the community are getting together. You need to be your own solution. You need to be the one that's going out there and go to the courthouse and go find people that are being foreclosed. Go find 4, 5, 6, 8, 10 people and bring them into your group and go, look, I want to help you. You help me, I'll help you. Because, as the song used to say, I think it was the 60s, together we stand, divided we fall. And I will tell you something. There is a massive amount of truth to that. And the more you play as a team player, the better it's going to be. So, you don't have to think that you're all by yourself. You don't have to think that there's not people out there that are willing to help you. And the more groups of people that we come together, I'm with what Evan and Dan just shared with me about their trustee termination and what they did there, if that guy had probably tried to do that on his own, it may not have worked. Because now, when they see 8, 10 people standing around looking at this, they know. And again, go talk. I went and talked to my local paper. I went and told the guy, and I said, hey, man, do you know what's going on? You know what's going on with the mortgages? And sure enough, guess what? His paper's doing so bad that he's having to lay people off, and he knows some of his employees are going to lose their house. They're going to foreclosure. So I'm like, so would you like a little bit of education? I'll be more than happy to educate you. And of course, publishers and newspaper, they want the facts. They want to make sure they can't print anything that's not true. And I said, well, then, go do your research. So, everybody out there, and again, we talked about it at the beginning of this call, your alphabet organization people, their families are getting their asses kicked too. And what these CIA and FBI and IRS and all these, Homeland Security and all these people that work for these organizations, guess what? They're watching their family go to foreclosure. They don't realize that, they think they're out there doing something to protect America and protect the citizens and the people of this nation. That's bullshit. It's not. You're working for the Rothschild cartel. You're working for the bankers. Nice job, guys. Keep it up, because you're going to destroy the actual fiber that this country was built on. And you're going to kill this country for your children and your grandchildren. So you better wake up, and you better start doing some research, and you better start realizing that all you're doing is working for the banks, and you're killing your own country, and you're destroying your own family. That's a fact, guys. You can't get away from that. That is exactly what's happening. So,
hey, Dave,
yes.
Remember your request to help the Ward family. Why not have them use the ratification of commencement tomorrow?
Well, it's interesting. You should ask that, Stephen, because they actually are, and okay. that is something. I believe their paperwork is in place, and but they're a little nervous, because you know what? They're not schooled like we are. I can go into a court, and the judge is going to look at you, and he's going to call your case, and he's gonna call your name and say, David Jones, are you here? And you stand up, and he's gonna look at you and say, are you David Jones? And then you very calmly go, well, my mom named me David, and my family name is Jones, but I'm not the procedural phantom or the all-caps fiction that's on your piece of paper there. But let me raise my hand in the air and say, on and for the record, that I'm the first-in-line paramount secure party creditor for the debtor. Now, does anybody here have any objections about what I just said? And, of course, if they say anything, then you just ask them, well, how would you know? Were you there? Were you there when my mom gave birth? Were you there? Were you in the delivery room? I mean, do you know who I am better than I am or who my mother is? So, you know, you can strike his stuff from the record. I am who I say that I am. And so my question is there anybody here, Judge, do you have a claim against me? You don't? Well, is there anybody else that has a claim here against me? No? Your Honor, let me ask you something. Do you have a ratification of commencement here today for me so I can see it? You don't? Well, let's see. If you have no ratification of commencement and you have no claim, we all know that with no claim, relief can't be granted. You know, but you never know. You know, as we all know, going into court can be a pretty scary, terrifying thing, especially if you have no idea what to say and how to present yourself. So I'm going to ask everybody on this line today to say a prayer for this family, for the Ward family. I will tell you that Mr. Ward is a minister. He sounds like a lovely man. I talked to him briefly tonight, and you know, I heard his wife talking in the back room. I think his son was on the call tonight, and you know, this is what's happening. Thousands and thousands and thousands of people are going to go into court tomorrow, and they're going to get their asses kicked. And they're going to get their asses kicked by a judge who is not really a judge. He's a black-robed administrator. He's wearing a dress, and he pretends to be a judge, and he's working for a corporation. And he's working for an organization that has an EIN number. And he's working for an organization that has a Dun & Bradstreet rating, and all he is a glorified bank teller, and he's there to extract wealth from the people. It's not about a law to help protect people or keep people safe or any of that. It's all about wealth extraction, man. And we know that. And you know, the more of these alphabet organization people that start to realize this and can help, it's going to be a beautiful thing, because they will eventually. And I've already had some feedback from a lot of them. They know something's wrong. They're pissed off. You know, a lot of the military people right now are pissed off. They've had enough, man. You know, they're starting to realize that, you know, it's calls like this, and it's the internet and the information that's out there, and people are starting to educate themselves. And, you know, if I could share one bit of advice with anybody on this phone, is that, you know, don't give up. Right. Don't walk away. Don't walk away from your home. There's things you can do. You know, right. Don't give in, because that's what they've got you right where they want you. You know, you're vulnerable. Go ahead, Evan.
Yeah, I was going to chime in. Another thing is, along the lines of what Dan had mentioned, is, you know, we get to these foreclosures, and they've got these 20-year-old kids propped up to do the auctioning. They don't know what the hell's going on. They don't know what they're doing. Okay, so it's not like you're going to face a big, fierce monster. You're facing kids that have been duped into doing the dirty work for these guys. And there are about 5 organizations down the chain. Here, the auctioning company works for another company that gets orders from the trustee, who gets orders from the servicing company, who works under the umbrella of the mortgage company, who's owned by a larger bank. It's, you know, they, you know, to me, that says that these guys are running scared. They're
sacrificing young men and women. You're exactly right.
Right, and
you know,
and they're dispersing their liability. They want to put as many parties between you and them as they possibly can.
And that's where you go up to them and you tell them, hey, listen, what's your name? John? John, how old are you? You're 20? Wow. I can't imagine what it would be like to go to jail, to go to prison at 20 years old. John, I want to show you a document, and I'm going to give you an opportunity because I don't want this to be an experience for you that you're going to end up in prison. But you see this document right here? It's certified here in the county. See that word right there where it says the trustee and the beneficiary? See these two guys on my right and left? He's the beneficiary and he's the trustee. If you go forward, if you try to go forward with this foreclosure today, you're going to jail. And I'm going to use that cop right over there to have you arrested. So you probably need to make a phone call, and you might want to give a whole deep consideration to what you're about to get yourself into and what you're about to do here today. So you look like a nice young man, and I'd hate for your parents to have to bring you, a file and a chocolate cake someday because you're spending time, in an institution because a bunch of guys gave you a bunch of information that wasn't true. So, I'm going to give you about a 5-minute offer of immunity here before I go over and tell that cop that if one word comes out of your mouth about this, unfortunately, and I've got 2 notaries here with me. These are state officials. We're going to have you arrested. So listen, you think about that and you have a nice day and walk away because that's what you got to do as a Christian man. That's what does it tell you in Matthew? You got to go to your brother and you got to warn him. You got to tell him, look, man, you're doing something wrong here. You're going to get your butt in trouble. And, you're allowing and using the fear of God, on your side. Then you go tell the sheriff. Sheriff, I just put that young man on notice. He's not the trustee. You know why? I have a certified document here that shows who the trustee is. This is out of your county record. Somebody asked me something a while ago about the bidding of the silver. You can also go to the foreclosure, get a couple of notaries, or if you can, it's always nice to have some notaries around. But even if you don't, you can take 2 or 3 friends if you can who's got some silver and bid on the property. And because you're the only ones there with lawful money, guess what? Your bid wins. So you let your buddy win for 10 ounces of silver, then you write up affidavits who bought the property on such and such a date, you have them notarized, and you put them into the public record into the real estate account. And now they got a real problem on their hands because now you can put liens. You guys, you bought it. You can go put a lien on the property lawfully. So, again, I know some people that have done that. They've shared that process with me and told me about it. And, that's something else that you could do. But the point is that there's things you can do. And one of the first things you need to do, in my humble opinion, is say, you know what? You're not stealing my property without a fight. It's just like the Congress lady here, I don't know how long ago it was, she was standing up there, and guess what she told the world? Don't leave your home. That's pretty gutsy coming out of a congresswoman. I mean, she just told people to stand their ground. Why? Because possession 9/10 of the law, and they know that. So, and the other good news is that, a lot of sheriffs are waking up. A lot of police officers and deputy sheriffs are starting to wake up. They're going, wait a minute, something ain't right here. How can all these cases come into court and the judges aren't making the banks prove that they ever owned an equity position in the note? That they're not the holder in due course. I mean, what are you doing, Mr. Sheriff? Because, a lot of sheriffs became sheriffs because they want to help people. A lot of them became sheriffs just because they want to feed their ego and they're power hungry and whatever. But, that's not the case with most sheriffs and police officers. They probably had a pretty good reason, in their heart, I would hope, to want to help and protect and serve and protect, because that's what it was really all about. So anyway, thanks for listening to me ramble there a little bit, because I think people need encouragement. I think they need some spirit. I think they need to know they can come to calls like this, and there's hundreds of people that are working together as teams, and every day, I believe our groups grow. There's just a lot more, people that are coming together, and we're getting stronger every day. Before we get off, we got a few minutes here. I wanted to ask if Tina wouldn't mind coming on the line and maybe taking us home with some information about the UCC1. Can we unmute
I'm
Tina,
unmuted. I'm here.
Oh, good.
Before we do that, actually, let me say one thing about all the people that have emailed from the call last week. Guys, I know you haven't heard back from me. I have not forgot about you. I got way more emails than I was expecting, which I should have actually expected. What I'm doing, I will get to you guys. I'm just kind of slammed. But what I'm actually doing is setting up an even bigger team of notaries because of the demand, obviously, for notaries for the declaratory judgments. We don't have enough to handle the requests that have come in. So I'm catching a couple of my notaries that I have here that are vaguely familiar. I'm catching them up to speed to get a better idea of what we can handle, and I will be getting back with all of you probably in the next week or two, so just be a little patient with me. Okay, I didn't forget about you guys. So I did want to drop in and say that real quick. And then this is something that we have been working on, and we've known about it for a long time, but we didn't really understand how the whole thing worked. We talked about one aspect of it at the beginning of the call, but it actually has to do with your note. You know, that's one of the biggest things that everybody says when you're fighting a foreclosure case is ask for the note, ask for the note, ask for the note. Whoever holds the note is the holder in due course, and they're the only ones who have the right to sue. Well, you're never going to get the note for more than just a reason that they don't have it. Most of the time they don't have it, but even if they do have it, they can't produce it, and here's why. First of all, under Title 12, USC 1813, that note was deposited as cash. So when you look on the back of the note, you're going to have the deposited slip. If that note were brought into court, that actually shows evidence in our favor and not theirs. That's going to prove our case that the mortgage was paid for in full. Okay, so that's one reason that you're never going to see the note. The note is a private instrument. The judge cannot look at it until it's made public. So how do we make it public? Record it in the county recorder's office. File it on a UCC-1. And I struggled. We've known about this for a long time, and I struggled with that myself, wondering, because, you know, they record the mortgages, but they don't record the notes. Well, there's a reason for that. If they were to record the note, they're recording our asset. And I really had a hard time grasping that. I guess I understood the basic concept in my head, but it was really hard to really completely wrap my hands around the fact that, guess what, guys, that copy of that note that you got when you sat down at closing, the blank one that you went home with, it's yours. It's your note. It's your instrument. It's your asset. And as of right now, you're the only one with an original. I am not giving you any legal advice, but just if that note is made public, you can bring it into the court as evidence on your behalf because it is your asset.
Right. One thing I want to add here, too, and one of our guys that's on the call here tonight is a notary. One thing you want to do as a notary is you want to make sure that your due presentments and maybe even your certificate of service or verification of service, depending on what state, because they use different language there, but you want to make sure you have a disclosure in there. And that disclosure has to be something along the lines that, hey, I'm not a party to this case. I gave not legal advice. I didn't offer legal advice. I was simply asked by so-and-so person to deliver these documents and record in a response, and I'm duty bound to comply with that. So you know, you just want to make sure you've got some language in there, and it protects the notary that you know that again, they're not giving out legal advice. They're not doing anything. They're just sending it. They're recording it being mailed. They're doing the stuff that notaries are going to do. So if you are a notary out there, make sure that you've got some language in your documents there that it's crystal clear so some attorney doesn't turn around and attack you and come after you. Because if you hit them hard, you hit an attorney hard, you know what? He'll turn and go after the notary. So just make sure that you're protecting yourself there with a good, strong disclosure of that you're not a party to the proceedings. You don't, you gave no legal advice, none of that stuff. So that's pretty important. And again, what Tina's been a wealth of information tonight, which she always is, which is always really great. And again, that just goes back to, she knows a lot about a lot of different things, but she's got a specialty in a couple of things. And if she wants to share with that, she can do that. I don't disclose that. But again, it just comes down to you got a lot of different people on this call, and there's a lot of them that have specialties on certain things. In fact, Jimmy, are you unmuted? Say something. Hit *8, if you will, and see if that'll unmute you. Jimmy, are you still there?
I'm sure he's on the call. Let me tell Matthew where if he hits *8, he'll show up as I'll Skype it to you. Yeah,
and then maybe Matthew can let him into the call. I did. He said he hit 8. He's not in there. Can you unmute everybody, Matt, and see if Jimmy will say something? And if we're going to unmute you, just let Jimmy talk here for a second. This is a man who is intensely.
Can you hear me now, Dave?
There you go. There he is. Hey, Jimmy.
Yeah.
And I just want to say one thing about you, and I don't get a chance to say many good things about you, so I want to go ahead and capture this moment. But Jimmy is amazing at doing research, so he's got something he'd like to share with the group tonight, and I'd love to let him tell you guys and share some of his wisdom with you guys. Go ahead, Jimmy.
Well, I was just going to reiterate what Tina said and what Dave said. We need more notaries out there. Anybody can become a notary. But once you start, if you did paperwork for somebody on a notary and then they call you up and ask for information, do not fall into that trap. You cannot give them any information if you're doing notary work for them. Somebody else you can carry on a conversation. But with all the stuff that they're doing with the wiretapping and everything, you never know what they're trying to do to set somebody up. But if you've got a group of 10 people, there's no reason why 4 of them can't become notaries. And then you start helping one another in the legal procedure like you're supposed to. If there's a court hearing or a court case or any type of thing like Dave has talked about or Tina, and you walk in there with 4 notaries and they're agents for the Secretary of State, if they try to run over that, if they try to intimidate you, you are an agent. You can file a criminal complaint. You can arrest or bond. There's stuff that we're figuring out now that we didn't know 3 and 4 months ago. We know now, and that's put us in a very, very strong position. If we just handle it like we're supposed to and obey the laws, even though they're not, we are. And if we do that, so if you've got a group going, you get out there and you find the people that are willing to become a notary. It is not a difficult thing, and as long as you follow the guidelines, you're going to be right in track with what we're trying to do, and it's going to be the protection for everybody. The other thing I was going to mention was this idea of when Tina was talking about the note and everything, we're uncovering, we've got more information coming in now than we can handle. And that means that the tide is starting to turn, and we can see the big difference. Yeah, they're still doing some crazy things too, but I think they realize that we've uncovered the hidden agenda that they've got. And I think they know they're in trouble. That's why I think you see a lot of this stuff with the bailout. Now that they're even selling houses at auction without taking them into the REO department. Doesn't that tell you that something is up? And that was the only thing I wanted to just throw out there.
Well, that's great. What a great distinction. And one other thing I'll add to that, notary, if you're building a team, you need offense and defense. And if you can find yourself a paralegal, somebody who can join that group, somebody that understands research and is willing to do that, me personally, I can't stand it. I mean, I can't stand it. That's not something I do. Oh wow! Here's something. One of our notaries just put something up here on the to post it. He says there's a good book for notary is Alfred Pombino. It's Alfred Pombino. And you can order his book, and there's a telephone number. It's 1-800-405-1070. So that's a really good book, apparently, that helps people with notary.
I have another. Dave, just a second. I have another suggestion. On these calls that we're on, like Greg Gentry's call and Rod Class and all them, we need people to step up to the plate and to take a 2-hour call and transcribe it. Now, I'm doing one from a week ago that's 6 hours, and I've spent about 12 hours on it so far. So I can't get the other calls done, but if somebody will respond to form90@yahoo.com, we will exchange help and information. If they'll sit down and just transcribe one call once a week and then get that information to us, because I'm a visual person. I hear, but I have to read it. So in order for me to read these things, if I have to write them out, I don't have time to read them then. So, if somebody can just volunteer just to do one call a week and transcribe it, yes, it'll take maybe 4 or 5 hours. But they'll learn as they're writing it out, they're going to learn. We're going to be able to explain to them what they wrote out, and it's going to help us tremendously as well, because there's about 7 calls that we need transcribed every week. They're too important just to listen one time and not glean from all of it that we can.
Here's the other advantage to doing this. You're going to join a team of people and become part of their camp and be able to tap into a massive amount of help and resource and knowledge and understanding. So, if you're out there and you think, wow, there's nothing you can do or help, man, it just raised its hand and made the opportunity available to you. So, thanks, Jimmy.
I'm going to interject too, because I'm part of that. I mean, Jimmy and I work very, very closely together. He's part of, we are all part of a core group, and if you guys can help us, you're helping yourselves as you help us get these transcribed, but as we can get this information and we can really dissect it and learn how to use it, we're going to pass it on to you, so it's really for the benefit of everybody. But we've got such powerful information coming in faster than we can digest it. With all the projects that we have going on and all the people that we're trying to help, and then at the same time we're being constantly bombarded with all this new information, we can't keep up, and the stuff is awesome and it's powerful, but we just need some of you to step up to the plate to help us get it done so that we can help you.
Well, and I'll add one other thing to that, and that is, you're dealing with people here that are paying it forward. And by the way, if you haven't seen the movie Pay It Forward, go watch the movie. It'll blow you away, and you'll understand how this will all help and work and interconnect us. So again, if you're out there and you're thinking, wow, I'd really like to be part of that group, here's a way to do it. So contact the person that got you on this call, and we'll do that. Anyway, we've got a couple minutes here left, and I want to turn this over to somebody who has a tremendous amount of knowledge. And Wes, are you out there? Can we hear you? Hit star
he's
8.
Muted. Yeah, he's muted right now. He's going to show up, Matthew. He's going to show up the same as Jimmy did. In the same.
There it is. I just came up.
Okay.
Yep.
Okay, he's on. Go ahead.
Go ahead, Wes.
Can you hear me, guys?
Yep, loud and clear.
There we go. I wanted to add something too. Just listening to you guys talk. Along the lines, the gentleman just spoke a few minutes ago was my father, Jimmy. Today's a good day, so I'll claim him on today. He made a very important point that there is so much going on, and we are all learning so much at such a rapid rate that the powers that be, or used to be, are coming down because they're doing things now out of haste and out of panic, if you will. I'm seeing a lot of things that I haven't seen the last several years that they're doing now more blatantly, more frequently, and by us knowing more information and taking that step forward and learning what's going on and putting the faces to the grill and turning up the heat, you're going to make these people do stupid things that they normally would not do, and it's going to actually make your victory about 10 times easier, because now when you push them into that corner and they know they've been pushed into a corner and you can catch them on it, they're going to easily let it go and go fight somebody else, because they're going to realize they did something they shouldn't have done. And not only are they facing a defeat, but in many of these cases, they're going to be facing jail time, huge fines, loss of income on their behalf, because they're going to be out of a job for a number of reasons. So just be on the lookout for that. If you've done any, a lot of people do the spectator. They're watching to see what's going on, And me, myself, even the last several days, I've seen things that you hear things from other people in the field that said, yeah, this is the way it used to be, like even foreclosures. I come from a real estate background, and I remember we used to go to the sheriff's sales, and you'd have maybe 3 or 4 there a week, and it would be dull and boring and everything else. But now, I think the gentleman said earlier that they're having 2 or 3 people going simultaneously. Well, you don't know what's going on behind those scenes with those foreclosures, because there's so many coming in, and because people are figuring out what's going on. They're doing things they shouldn't be doing. I've caught 3 foreclosure actions just this week where assignments, and this again stays just in their realm, just on their side, without going onto the box and doing anything funny or anything else. I've seen 3 cases, and all 3 are done by the exact same lender, where they've done assignments 2 and 3 and 4 months after the action was started. That is fraud. That is, you can throw that out in a heartbeat. If you challenge it, you can run over with a car. It's that easy. And I'm telling you, and people are losing left and right because they're not looking at even the simplest things that they wouldn't have, 2 years ago, a year ago, 3 years ago, you never saw this. But now that things are moving at such a rapid pace, they're being forced to do things they normally would not do because people are finding out what's going on. Keep that pressure on them. Let them know that you know what they're doing. And let them know that they're not going to get away with it. And let them know that if they take one step out of bounds, one way or the other, you're going to tackle them. And they need to know that. I just wanted to add that into the discussion there.
Yep. Well, and we all know what happens when you walk into a dark room and you turn a light on. Cockroaches and rats have a tendency to run. Absolutely. And a couple things here I wanted to say. Form90@yahoo.com. Go check that out. Form90@yahoo.com. And then also with the end, here it goes. I think that's it. Okay, so, and then we have Notary Public Handbook National Edition. That was the Alfred Palmino at 1-800-405-1070. You can order your copy. So let's see. I think that about does it, boys and girls. Anyway, thanks everybody for being on the call tonight. And I want to thank my host. Some of you know who he is, for allowing me to come on here. I'm very humbled to come out here and talk to you all and be part of you and be part of this solution. So remember to pray to your Lord and Savior and give him thanks for everything that he's doing in your life. And we'll see you next week on Wednesday, 8 o'clock Eastern. God bless. Have a great evening. Good night, everyone.
Thanks, guys.